A good Wednesday afternoon to all of you, and I hope everyone is having a lovely day. My name is Ng Kim Beng. I'm a partner in the International Arbitration team at Rajah Tann Asia. A very warm welcome to all of you, and thank you for joining us for the launch of Arbitration Asia, a one-stop online resource that is dedicated to the latest developments in international arbitration with a focus on Asia. The web resource that I'm about to introduce you to is a labor of love born through the combined efforts of many in Rajah Tann Asia. About a year ago, and leading up to our launch today, a team of editors-in-chief, country editors, administrators, and local liaisons was assembled from across our 10 offices in Southeast Asia, all working together to set up this special platform that has been designed with the intention of sharing insightful analysis of the latest arbitration-related developments, case alerts, and events or happenings across our geographical footprint. More on the purpose and objectives a little later as I take you through a mini guided tour of the website. Before that, as part of our launch event today, we have put together a fireside chat with our leading senior international arbitration practitioners from across the Rajah Tann Asia network. They will be sharing their views and experience on the latest arbitration trends and developments in the region. This session will be moderated by Senior Counsel Francis Xavier, who is the regional head of Rajah Tann Asia's dispute resolution team. Francis will be joined by Senior Counsel Yeap, who heads the international arbitration practice in Singapore, as well as Hertiawan, partner and joint head of disputes practice from Assegaf, Hamzah and Partners in Indonesia, and member of the SIAC Court of Arbitration. Yeap, managing partner of C&G Law in the Philippines. Surasak Vajasit, managing partner from our Thai office, and Dr. Quang Chow, managing partner from our Vietnam office. Without further ado, I shall now hand over the stage to our panelists. Gentlemen, please.
Dear friends, welcome to the launch event. It gives me great pleasure to say that we have a stellar cast of panelists here from 5 jurisdictions with us. To kick off, I want to start with Andre. Andre, you've been right at the forefront of arbitration in Singapore, both as counsel and arbitrator. Can you tell us a bit about the recent developments in Singapore impacting the practice of arbitration, which will also impact Singapore's position as a top global seat in arbitration?
Well, I think there are numerous factors, and historically, I think it all basically got launched with, basically the launch of SIAC as well as the Maxwell Chambers, which had dedicated facilities, state-of-the-art facilities for arbitration. But I think more importantly, we had the necessary underpinnings. So first, we had a very pro-arbitration judiciary, and a very sound judiciary at that. And secondly, I think we had also a very, very responsive legislature, which was constantly looking at how to improve our arbitration legislation, which is the International Arbitration Act, and which is, of course, based on the model law. But more recently, I would say that if we look at it, certainly there are various factors which has, I think, finally catapulted Singapore to the arbitration stratosphere, if it were. And I think firstly, partly in recognition, and I think as part of that fuel, ICC for one in 2019 opened a case management office in Singapore. We would like to think that that's a contributing factor both to the growth of arbitration in Singapore and also to ICC's own case figures, which I think for 2020 hit close to 950 cases. And where SIAC is concerned, SIAC has been constantly on the marketing forefront. But not only that, I think the SIAC has always sought to tweak its rules and to make it as attractive as possible for litigants, right? And more importantly, I think they've always tried to stay at the cutting edge in terms of their rules. They were the first to have emergency arbitration rules. And more recently, they tweaked their rules to deal with multiple contracts, joinder of parties, consolidation, not easy areas for arbitration. But certainly, I think that has widened the appeal. And in addition to that, with their constant marketing efforts, I think SIAC has hit over 1,000 cases in 2020. And that's the first time they've crossed 1,000. And on a combined basis, Singapore is now at least seen as on par with London as an arbitration venue, and that's a joint top placement. I just wanted to say that, you know, the ingredients that go into this, there's so many critical ingredients, it's difficult to identify all of them. But in addition to it, in addition to these factors, there's the push to have Singapore as a venue for investor-state arbitrations. And I think that's a concerted effort by the government, and we've seen Maxwell Chambers sign an MOU with ICSID to push for Singapore to be used as a venue for ICSID arbitrations. SIAC itself amended its rules, I think, way back as early as 2013 to accommodate treaty arbitration so that they could administer investment treaty arbitrations. And I think last but not least is a geopolitical factor. We've been blessed with a fantastic geographical position. You know, we are in the midst of a growing area and we are the epicenter of trade. But in addition to that, I think it's fair to say that when parties look to arbitrate, they always look for a neutral forum. And China has grown in a huge way. And when parties, foreign investors go into China, I think they're always looking for a neutral forum. Previously, they may have been happy with Hong Kong, but as you know, Hong Kong has folded back into into China. There's probably a greater reluctance for international investors to arbitrate, in Hong Kong if one of the counterparties is a Chinese party. So I think that has also blessed Singapore, and Singapore sits as a ready venue for cases involving Chinese parties. And you know, India is growing in a big way too, and you know, the Indian parties, when they look to arbitrate, especially if there's a foreign investor, Singapore is probably close, convenient, great connectivity, and we see lots of Indian-based arbitration taking place in Singapore as well. So I think all these have come together to really catapult Singapore to where it is today.
Thank you. Thank you, Andre, for that overview. I want to capitalize on the fact that we have so many jurisdictions on the panel. So I want to go on a tour so that the audience get a good sense of, you know, what are the key developments in the region. I'm going to turn first to Thailand, which is a model law country, and to Kun Surasak. Kun Surasak, could you tell us, you know, what is the state of play of arbitration in Thailand? And in particular, if you could also tell us about, you know, how readily would Thai courts enforce both domestic and international arbitral awards? Over to you, Kun Surasak.
Thank you, Francis. I think in Thailand, the current law on arbitration in Thailand is the Thai Arbitration Act, AD 2002. I mean, which mostly follow the Australian modern rule on international arbitration. And the Act draws no distinction between domestic or international arbitration. Both are treated in the same manner. In this connection, I think Thailand is a party to the New York Convention on the enforcement and recognition of foreign award, which came from a member country of the New York Convention. So therefore, most of the award, or most of them that come from the member country would be enforceable in Thailand. Under the current Thai Arbitration Act, I mean, the award have to be enforced in Thailand within 3 years after the award become enforceable. Please note that in Thailand, I mean, under the current practice, the Thai court, I mean, the enforcement of the foreign arbitration award in Thailand is not merely an administrative process. You need to introduce documentary evidence or a witness statement to the Thai court to enforce the foreign arbitration award. However, I mean, in this connection, I think Thailand, probably the Thai court would not really examine the facts or monitor the case. I mean, most of the current Supreme Court decision confirm that principle. So it's probably a good sign. And usually enforcement of foreign arbitration award would not take, I mean, would take about 1 year. However, in case the opposite party, object to the application to enforce, it could take something like almost 2 years. So I would say that, currently the current situation of enforcement of arbitration award in Thailand seems to be quite good in the sense that you know for certainty regarding the legal principle that the Thai Supreme Court will adopt. So the Thai Supreme Court seems to be more aware of the obligation under the New York Convention, and they seem to know that the grounds of rejecting to enforce the award have to be admitted to the fact that to the law that provided in the Thai Arbitration Act, which mostly follow the Ausical model law. Thank you, Francis.
Thank you, Kun. Thank you for that, and I do note that you previously served as a sitting judge in the Thai courts. We now move across to Vietnam, Vietnam, which adopts key principles of the model law, to Dr. Quang. Dr. Quang, could you answer the same question? What is the state of play of arbitration? And in particular, I think many of us are interested to keep a keen finger on the pulse of, do the Vietnamese courts enforce international arbitral awards and domestic arbitral awards? Over to you, Dr. Quang.
Thank you, Francis. I think first, we know that Vietnam, had been a member of the New York Convention since 1995. And then we have a law on commercial arbitration back to 2010 that was adopted by Circuit of Uncharted Model Laws on Arbitration 2006. The overall recognition and enforcement of foreign arbitral awards in Vietnam are two separate steps under the law on civil procedure and the law on civil enforcement, respectively. So since the law on commercial arbitration produced back in 2010, they significant development. I can say that before the law, Vietnam we have 5 local arbitration centers, but now we have more than 35 local arbitration centers. That's in recent years. So if we base on annual report from VIC, which is Vietnam Center, the number of awards that have been set aside by the cost might to compare with total central every year. So VIC is remained the national. On the foreign side, according to a report from the Ministry of Justice, out of 85 requests for recognition reforms and foreign arbitration in Vietnam, they about 50% of them have been enforced. Thus, however, enforcement could still be improved by providing more and clear guidance. So Vietnam, as a civil law country, the court here in Vietnam, we still very heavily rely on written legal documents to render final decisions. So having clear guidance might have to significantly reduce the record award being set aside. So the court system also built for a system from local and international institutions law for just, and also as we are not really familiar with law or practice related commercial especially.
Thank you, Dr. Quang, for that helpful review. It is helpful to know that at least, the track record is that at least 1 out of 2 would definitely be enforced in Vietnam. I move across to the Philippines. Ben, you've been at the forefront of developments in arbitration in the Philippines. Can you tell us similarly what's the terrain and how is the state of enforceability of awards, international and domestic?
Sure. Thank you, Francis. It's good to see everyone. First of all, I should point out that the Philippines is a signatory to the New York Convention. It is also a model law country. although I must clarify that it is the 1985 version of the model law that has been adopted by the country. The entirety of the 1985 version was incorporated as part of Philippine law back in 2004. Unfortunately, the Philippines has not yet adopted the 2006 amendments, although I understand that there's a movement to do so in the near future. Now, as for the state of development of arbitration, and in particular the enforcement of arbitral awards in the Philippines, I'm happy to report that the Philippine Supreme Court, which is the country's highest court and also has administrative supervision and authority over all other courts in the country, the Supreme Court has adopted a favorable attitude towards arbitration and arbitral awards, including foreign arbitration and foreign arbitral awards. We can see this from the special rules of court on alternative dispute resolution that was issued by the Supreme Court way back in 2009. We can see this also in more recent decisions of the Supreme Court since 2018 up until this year, where the Supreme Court noted and then reiterated that there is a state policy in the country in favor of arbitration and the enforcement of arbitral awards, and that therefore the courts should adopt the majority and narrow approach that has been adopted in other jurisdictions in determining whether enforcement of an award is contrary to public policy. So I would say from all this that as far as the Philippines is concerned and as far as the Supreme Court is concerned, it's been quite encouraging as far for arbitrations. Francis.
Thank you, Ben. That's very helpful to know that Philippines is firmly entrenched in the international philosophy of enforcing arbitral awards. Last but not least, Jakarta, I'm very pleased to introduce Pak Eri Hertiawan, who is the first and only Indonesian lawyer ever appointed to the SIAC Court of Arbitration. Pak Eri, could you answer the same question and tell us what's the landscape in Indonesia, especially on enforcement of arbitral awards as well?
Okay, thank you, Francis and Andre. As you may already aware that Indonesia is also party to the New York Convention, so it is all the same as our colleagues' country, as mentioned before. Well, Indonesian arbitration law was promulgated in 1999. So you can imagine that it is almost more than 20 years ago. And initially, Indonesia was considered as quote-unquote unfriendly country for arbitration. But now such statement is no longer exists, where the position of the Indonesian Supreme Court uphold the arbitration clause. The Supreme Court position is, honoring the agreement made by the parties. So even if there is a district court ruling that invalidates the arbitral award, but at the Supreme Court level, statistically speaking, there are many decisions of the district court which is then overruled by the Indonesian Supreme Court. And this indicates that the arbitration is accepted by the business actor, by the business practice in Indonesia, and also the parties' agreement concerning the arbitration to solve, to settle the dispute in the arbitration forum. And, the parties' agreement to be bound by the arbitration clause is very much recognized by the Indonesian court nowadays. And that's why I mentioned earlier that Indonesia now should be considered as friendly country to the arbitration. And also related to the enforcement of the foreign arbitral award, I once made a research to the District Court of Central Jakarta. Well, the District Court of Central Jakarta is the only district court in Indonesia who has the authority to accept to register the arbitral award to be further implemented in Indonesia. Well, based on my little research, I found that there are at least 80% more of the foreign arbitral award that can be registered in the Central Jakarta District Court. Of course, there are further steps for the implementation, for the enforcement of the foreign arbitral award. But at least the registration in question, once the award has been registered, then the next step is to ask the losing party to voluntarily enforce it. And the involvement of the district court is only where the losing party is not voluntarily implementing or enforcing the arbitral award. So it is also, if it is not implemented voluntarily, then the winning party can ask the chairman, of course, to issue a court order. So what I'm trying to say is that it is now consistent. The position of the Indonesian Supreme Court is now clearer that the arbitration agreement is to be upheld, and based on the pacta sunt servanda principle, it should be bind as if it is a law between the parties. Over to you, Francis.
Thank you, Pak Eri. That's heartening to know, because a lot of traffic that comes through Singapore does in fact relate to disputes arising out of Indonesia. I now want to turn back to Andre. Andre, Singapore obviously is firmly pro-arbitration and pro-arbitral awards. But because of the volume of cases that's going through our system, we are certainly seeing a burgeoning number of setting aside applications, as well as other court-related applications. Could you just give us a sense of what has been the reaction of the Singapore courts, and how have they tackled this? Andre?
Well, I think the Singapore courts have been consistently pro-arbitration. It's exceptionally difficult to set aside an award. It's not an appeal. And generally, the only basis where you could probably have a realistic chance of succeeding in setting aside an award is on the basis of some breach of natural justice on the part of the tribunal. And certainly, that's not easy to establish. But even in cases where that has been established, the Singapore courts have on occasion, if they think that there is some prospect that the arbitral tribunal may reconsider the decision one way or the other in those difficult areas, they could actually remit the award back to the tribunal. And we've seen that happen too. In fact, we did the first case where it was remitted. But even after the remission, the tribunal refused to cure what the court thought was a defective approach, and the court then went on to set it aside. But importantly, I think apart from just setting aside, we're seeing a lot more arbitration cases going to court in different ways. One, of course, is enforcement, and the other is in relation to even interim issues. But let me give you one very interesting example, actually. And this was a exit arbitration case that found its way to Singapore. And in that particular case, one of the parties there were Vedanta, and on the other side was India. And India had come to the Singapore courts to seek a ruling, basically, that under the lex arbitrae, which is the law of the seat of Singapore, law of Singapore as the seat, that there was no confidentiality obligations attached to treaty arbitrations. So they had invited the Singapore court to make that ruling and to make a determination, actually, that all the documents that were used in the arbitration were not confidential. This was despite the arbitral tribunal itself having made a ruling in relation to non-disclosure of certain documents for various reasons which I don't need to go into. But suffice to say that the tribunal had considered confidentiality as one of the factors under the lex arbitrae, i.e. under Singapore law. But the tribunal made it clear that that did not prevent them from ordering disclosure if they wanted to. And there were various factors to look at in the overall scenario. But here was India actually inviting the Singapore court to make a ruling as to the lex arbitrae, because they said, and their argument was that to the extent that the tribunal had made a ruling in relation to the obligation regarding confidentiality under Singapore law, they were not the best parties to make that decision because they could not develop the lex arbitrae. And the lex arbitrae should be the sole purview of the Singapore courts. Very ingenious argument, actually. So when we came before the judge and eventually before the Court of Appeal, they both ruled in favor of our client's Vedanta against India. And they took the position, a very, very pro-arbitration approach, basically that it was not for the courts to be giving a ruling which India could then take back to use to put, for want of a better word and to use a neutral word, to persuade the tribunal to change their minds in relation to their earlier ruling. Of course, one could say that's a means of putting pressure on the tribunal rather than something of aid as a persuasive force. So that's another very good example we see of a very pro-arbitration approach in Singapore. And I think the third thing we've been noticing is that there are more enforcement cases, especially involving states, coming through the Singapore courts. And I think that's for various reasons. In Singapore, basically, there can be enforcements against states under Singapore law. There is only very limited immunity under Section 11 of the Immunity Act. And for that provision, basically, there is no immunity in relation to commercial transactions, basically. So on that basis, I think we've seen more enforcement cases coming to Singapore courts. So the Singapore approach and the Singapore legislation here in terms of immunity is different from, say, Hong Kong, for example, where Hong Kong had refused to rule in favor of enforcement against Congo, the Republic of Congo, principally on account of the fact that, well, Congo is a sovereign state and we wouldn't enforce it against a sovereign. Even though that transaction was more a commercial transaction rather than a sovereign one. So I think various factors have come into play here, but certainly I think they've all combined to keep Singapore on the forefront of arbitration. And together with all this, I think we've been seeing a surge of arbitration-related cases in court. But despite all this, I think the Singapore courts have firmly landed and continue to land on the pro-arbitration front, as it were.
Thank you, Andre. I'm going to ask a question now of Kun Surasak, but before I do that, I just want to warn Pak Eri that there is a question from Bernard Lim as to what are the percentage of cases where a foreign arbitral award enforcement is refused at first instance, right, before it gets to the Supreme Court. So I'll come back to you, Pak Eri, on that. You might mull it over.
Okay. Thank you for the question. Based on my research, again, statistically speaking, I would say that the enforcement of the foreign arbitral award is very, the rate is very, very high. Although, yes, there is in practice that the party who wish to enforce the arbitral award, they face a little bit difficulties. But again, statistically speaking, I think it would not be more than 5%. So if we compare with 100% of all of the cases, for a foreign arbitral award to be enforced in Indonesia, and 5% is, I think, very small. Yes, there is in practice, but the rate is very small. Thank you, Francis.
So you would say, just to clarify, Pak Eri, you would say 5% of arbitral awards will not be enforced at the Supreme Court stage or at the first instance stage?
At the Supreme Court stage, yeah, because
Right.
Supreme Court is the highest level of the Indonesian court, and they have the authority to overrule or to strengthen the decision of the district court.
Sure. If you do have the statistics for what level of refusal to enforce is there at the first instance, let us know. But I'm going to switch to Thailand while you're thinking about it, Pa Eri. Kun Serosa, there were recent amendments to the Thai Arbitration Act. Does it mean now foreign counsel and foreign arbitrators can practice arbitration in Thailand? Please let us enlighten us.
Okay, thank you, Francis. I think, the Thai government would like to promote Thailand as an arbitration venue for international arbitration. So there were amendments to the Thai Arbitration Act, AD 2002 in 2019. Allowing foreign arbitrator and foreign lawyer to act and to participate in international arbitration in Thailand. So basically all the work permits requirement and the visa rules have been greatly relaxed. And they introduced special work permit for those who would like to work as arbitrator in Thailand or to act as foreign counsel in Thailand. They introduced, they amend various laws, including the work permit, the labor law, and also the Investment Promotion Act. Basically, they amend a few laws to make sure that Thailand could be the competitive venue for international arbitration. And in practice, right now, all the arbitration is still in Thailand have been quite supportive to help foreign arbitrators and foreign lawyers who like to participate in international arbitration in Thailand. They would really provide support in terms of doing applications and giving advice. So, I would say that the recent development is quite positive. Basically, the Thai government, have changed attitude a lot concerning foreign lawyer working in Thailand or foreign arbitrator coming to Thailand. Remember in Singapore, it's quite relaxed. I went there once. Didn't need anything to conduct arbitration in Singapore for the whole week. But in Thailand, previously you need, and there is an attempt not to, basically they were in a discouragement for foreigners or foreign counsel to act as arbitrator or counsel in Thailand. The idea is there's a lot of red tapes procedure before you can obtain work permit and visa. But right now, I would say that the recent development proves to be quite positive, and experience show that for foreigners who like to act as foreign arbitrator or counsel in Thailand, they would get support from the Thai government agency and Thai arbitration institutes. Thank you, Francis.
Thank you, Kun. We, of course, want to see you more often in Singapore, nevertheless. I'm not going to switch. I'm not going to switch to Dr. Quang. Dr. Quang, what are the decisions of the Vietnamese court that has caused some consternation amongst international commentators? And you would be aware of this, is decision number 11 of 2019 of the Vietnamese court, where an arbitral award was effectively not enforced because one of the grounds of the reasoning of the Vietnamese court was that even though the arbitration was seated firmly in Vietnam, but because the venue, which was the convenient place of the hearing, which was initially agreed to be in Vietnam, as between the parties, right? The parties had agreed that the physical hearing, the venue should take place in Vietnam, but the arbitral tribunal had overridden the parties and ordered it to be heard in, I believe, Singapore and Tokyo, or in Japan. And that was one of the reasons why the Vietnamese court said this award cannot be enforced. Can you comment on that for us, please?
Okay, thank Francis. I think it's good that, so actually we have two cases that the foreign counsel and also foreign arbitrator, they are fully aware of. One of the case I mentioned, that the one of the judgment from the Supreme Court of Singapore have been recognized and enforced by the decision of the Supreme Court of Vietnam. I think that's one of the first cases. And the second case that you just mentioned, that's referred to, they contractual dispute between China consortium with the another local hydropower stock company. So that the very high value dispute, and it took the arbitral tribunal and the party for 5 years to finally resolve the case. But in the end, the award was set aside by the court. So that back to my understanding, they feel ground for the court to decide to set aside the award. But one of the very critical ground because the tribunal, like you said, decided to change the physical venue and the hearing venue to location beyond the parties' consent. So because of that, the tribunal was found to fail to carry out the arbitration in accordance with the parties' agreement. They another ground, like the tribunal also failed to take into account the respondent witness evidence, for example, based on the IBA's rule on the taking of evidence, or another round because the tribunal failed to conduct its own assessment of the quantum of the damages. But the main route still back to the point of whether the tribunal decided to change the hearing venue to a location first from Hanoi to Singapore, later on after they went to the Osaka, Japan. And because of that, the court said that that's also found to reach the laws on commercial arbitration. And the tribunal had to be bound by the consent of the party. So without the consent of one of the parties, for this case, for example, the disapproval from the respondent, that because of that, the court also decided to suspend the award. The legal question arising from that cases. One, from Vietnam, we consider whether the court observed to say like, okay, if you change the venue of the hearing, that also led to another consequence to say change a place of arbitration, whether or not. And then from my observation, I believe the court also believe that because of physically you change the venue, that also can impact on the change of the place of arbitration because of what we set aside. So overall, it's hard to say that, as I said, the court set aside the award only because of the changing of the parties' free venue without their consent, but also another round. But still arguable whether or not the decision 11 of the courts consider as the step backwards against the achievement of the arbitration community in Vietnam. Then also, they also need to, continue working with the Supreme Court and also the Central Authority to have more productive guidance on this issue. And if I can say, like, for incentive to be taken away for foreign arbitral tribunal, or particular for foreign counsel, though I involved with the Vietnam set, they should take the case as the example to avoid such kind of like misleading, avoid facing the same situation. Whether the court somehow they also believe changing the physical venue be considered as changing the place of arbitration, and then because of that also impact on their authority authority of the national courts, though have authority to supervise such kind of arbitral proceeding within Vietnam under New York Convention. Thank you. Over to you, Francis.
Thank you, Dr. Quang. I'm going to ask a slightly less heavy question to Ben, my friend from Philippines. Ben, could you tell us what has been the impact of this ravages of this virus called COVID-19 and the impact on arbitration practice in the Philippines?
Yes, sure, Francis. Well, happily for lawyers in the country, while work generally slowed during the first 2 months of after the pandemic started, at least in the Philippines in around March 2020, it has picked up considerably since then. This is no different for arbitrations and arbitration-related matters, which have actually increased year on year. This is our experience in CNG, and this has also been the experience of the Philippine Dispute Resolution Center, which is one of the local arbitration institutes in the country. Of course, as in other countries, the pandemic has forced a change in the way arbitrations are being conducted, and perhaps for the better, who knows? For example, in the case of the PDRC, all its merits hearings since the pandemic began have been conducted online. Now, whether or not this will be the case when the situation finally normalizes, will of course, or has of course, yet to be seen. Back to you, Francis.
Thank you, Ben. Now, I just want to tell the panelists that there is a question from Ashraful Hadi about how successful have there been enforcements of arbitral awards against states, and you will see that on the screen. I'll come back to that, but before I do that, I just want to go over to Pak Eri. Pak Eri, you know, one of the things that we learn in arbitration practice in theory is that apart from getting the tribunal to rule on the basis of law and fact, strict law principles, parties can actually agree under party autonomy to let the arbitrators rule on the basis of right or wrong in a particular case, not strictly according to principles of law, acting as amiable compositors or acting ex aqua et bono, right? To what extent have you seen this? In my years of practice, I've never seen it happen in Singapore, in the cases I've been involved in. Tell us about your experience and in Indonesia and your thoughts on this, Pak Eri.
Okay, thank you, Pak Francis. Well, for the lawyers, I think we all knows what is the meaning of such legal concept, ex aqua bono. But for the non-lawyers, I would a bit explain that according to I refer to the law dictionary that defines the ex aqua bono as the quote-unquote injustice and fairness, according to what is just and good, according to equity and conscience. So it is not only for the tribunal to decide based on the contract, but also again, as defined in the law dictionary, it would also be possible to make a decision based on justice and fairness. The term typically refers to a court or tribunal consideration of a dispute according to what is fair and just, given the particular circumstances, rather than strictly according to the rule of law. Well, the use of this legal concept, ex aqua bono, we can find it in the international arbitration rules. For example, in SIAC, yes, there is also a provision concerning the use of such legal concept. Under the Indonesian law as well, if we refer to Article 56 of the Indonesian arbitration law, it must be, the use of such legal concept must be based on the express consent of the parties. So it cannot be using the doctrine of quote-unquote agreement by conduct, for example. It has to be expressly stated in the agreement. It has to be stated verbally as well in the hearing, during the hearing, and therefore the tribunal shall have such an authority to make a decision based on such legal concept, ex aqua bono. But again, when we refer to the Indonesian arbitration law, there are one particular articles, provisions in the law, which do not provide the main element of the when the party try to use such a legal concept, but it is elaborated in the elucidation. As you know, the elucidation is an elucidation. It is not the law itself, and therefore I think when we are discussing on the Indonesian arbitration law, which provision that must be amended, for example, then I think this particular article should also be considered to be amended. The ex aequo bono may only be used by arbiter if the parties expressly agree. When I refer to the Gary Bond's book or journal, he also mentioned that tribunal is only 2 or 3% of arbitration cases annually apply ex aequo bono. So it's very small cases that has been decided under such legal concept. And it also, when you use that legal concept ex aequo bono, it poses a risk that there might be an over judicialization, and this is interesting, and I think it is important. It is susceptible to challenge. I mean, the enforcement of the foreign arbitral awards, which the party do not agree, but the tribunal makes such decision based on such legal concept, then there might be a risk that there will be a challenge when you try to enforce it in Indonesia. Thank you. Over to you.
Thank you. Now, I'm going to move quickly back to the question that was posed earlier on, as far as the panelists are aware, how successfully have they managed to get money out of awards against sovereign states in your respective jurisdictions? And Anirudh Bhatti has added the question of to what extent will the doctrine of sovereign immunity also come into play? I think that's something that Andre spoke about a bit earlier. So I'm going to throw this question open. To what extent have you been actually able to enforce treaty awards against states, and to what extent does sovereign immunity, the doctrine, play a major part? I'm just going to go through the room. If you have anything to say, just feel. Andre, do you want to say something?
I think certainly in terms of enforcement, I think that the question made reference to a sovereign guarantee. So it wasn't so clear to me whether it's a question of having already obtained a favorable judgment or arbitration award against one party and then looking to recover against a sovereign state on the basis of a sovereign guarantee which that state has given, right? Or whether you are suing directly on that sovereign guarantee and you have successfully, obtained an arbitration award on that sovereign guarantee, for example. But I think states being states, some states which are more respectable and they are more prepared to pay, some of them will make life a bit more difficult for you, and you may have to look for a suitable jurisdiction where the state has assets, where you may have to then look towards enforcing against those assets, right? That's in broad general terms.
Anybody else wants to add anything in terms of experience in this sphere? I'm just going to quickly go across the room. I've got one more question to deal with. Kun Surasak, anything?
Well, I would like to share my view. I mean, the legal issue that you have just raised had been widely debated in Thailand when the Thai government lost in the waterfowl case. And there have been attempts to seize assets of a lot of companies that the Thai government majority owned. But basically, finally, there was a seizure of a loyal aircraft, right? And then the Thai government basically pay the whole thing under the award under the BIT. So I would say in Thailand, I think that basically a matter of principle, even though in theory there is a sovereign immunity, but in practice, I believe that after the water bow, the Thai government is really aware that the reputation is more costly than the legal theory. I think if they got a foreign award against the Thai government, I think the government finally would pay. That's my view.
Thank you, Kun Surasak. That's helpful. Dr. Kwang, you had something to add?
Okay, so very practical, perspective from Vietnam. So, how to enforce Assegaf, like treaty award or investment treaty award in Vietnam, also very much depend on what kind of dispute. So normally, Vietnam, so far we have more than like 63 BIT and FTA to be signed up between Vietnam with like another more than 60 countries over the world. And then if they any investment dispute under certain BIT, subject to our arbitration clause or dispute settlement clause as set out in Assegaf BIT. As a matter of practice, so far I'm not aware any like investment dispute between the state, but then there are number of dispute between like foreign investors in Vietnam, though like exercise their right to take a lawsuit against the government or the state-owned corporation to number of international arbitration forum like ICC, ICSIC, and under UNCITRAL rules. So how to enforce this? Actually, we have very good, very strong case study for that. For example, like back to like 20 years ago when one Italian company, they took a lawsuit against, for example, Vietnam Airlines. That is state-owned corporation. And then because of Vietnam Airlines, they failed to show up in the court and so on the like international court in Milano, in Rome, and also later on in Paris. And when the claimant they got the award, and then automatically they enforce it. They cannot get it recognized and enforced in Vietnam, and then they have to recognize and enforce somewhere else. For example, in Paris, and then they apply some kind of injunction release, or we call it emergency measure, to block some kind of account of the Vietnam Airlines. And then because of that, the government also involved and then to subsidize for Vietnam Airlines to resolve it. But practically, most of the case, regardless that number of cases have been handed, and even the tribunal issued the final award to against the government here. But then at the end of the day, we also try to reach amicable settlement under separate, even like during the arbitral proceeding, even after completion of legal proceeding. And then the government still excited to settle amicably. And then when you reach the Assegaf settlement agreement, and then the enforcement it would be much easier. That practical in Vietnam.
Thank you. Pak Eri.
Yeah, Pak. Thank you, Pak. On the same question, Pak. We also in Indonesia have the same provisions, which basically that the party cannot ask the court to cease to make to issue an attachment order against the state's assets. The interesting thing is that where the asset is managed and owned by the Indonesian state-owned company, which is the government. The government of Indonesia is only own the shares in that company. So that has been a discussion among the lecturer and also the practitioner in Indonesia, whether the Indonesian state-owned company Indonesian state-owned companies' assets can also be attached. Again, there are also agree and disagree on that. And on a separate note, for the bankruptcy, for example, there are also requirements under the Indonesian bankruptcy law, which requires the Ministry of Finance to declare bankrupt for this Indonesian state-owned company. So So the discussion is still going on. There are cases that recognizing the attachment on the assets of the states or the we call it BUMN, Indonesian State or Company. But also there are cases which they do not grant the request for the attachment order. Thank you, Pak.
Thank you. Ben, did you have any perspective from the Philippines on this question at all?
Yes, Francis, thank you. I think for the Philippines, well, first of all, the concept of sovereign immunity is separate from whether or not having waived sovereign immunity and having gone through the proceedings, the assets of the state can then be enforced against. The general rule really is that even if the state had waived immunity and then therefore participate in the proceedings, any awards against a state, typically you'd have to file a claim with the Commission on Audit, and there's also typically a requirement for an appropriation from Congress in order for that award to be enforceable against the state.
Thank you, Ben. That was helpful. Now, I want to move on to another question from Zaki Tanjong. Pak Eri, I have no clue what the answer is, so you will have to take it, which is, what is the impact of the ombudsman laws in Indonesia? Has it caused an increase in the rise of business disputes? And also, what is its impact on the enforcement of foreign arbitration awards? Pak Eri, are you able to? Yes.
Yeah, Pak. Yeah, they have. There are a division of authority, or as you understand, legislative, executive, and judicative, and of course, they cannot intervene each other. When we discuss about the enforcement of the or the implementation of the law, then the right institution for one party to send a complaint, I think it should be the Indonesian Judicial Commission. Indonesian Supreme Court also has the internal institutions within the Supreme Court who supervise the behavior of the Indonesian judge, same as the Indonesian Judicial Commission. So when this ombudsman cannot be relied on, then I think there are other institutions that parties can go to send the complaint, for example, i.e. this Indonesian Judicial Commission and also the Supreme Court supervisory body within the Supreme Court. Thank you.
Right, thank you. So I see that we have about 8 or 9 minutes left. I'm just going to go through looking to the future, right? Andre, first, I know that Singapore is considering a number of amendments, including an opt-in mechanism for an appeal on a point of law, right? If both parties agree. Do you want to just comment?
I think that's a very interesting proposition because very often you see in arbitrations awards where you look at the law, the determination of the law part of it, and you're a bit skeptical may not be the right word, but you might think that you could have arrived at a different landing. I think this is more relevant for certain type of cases than others. Most arbitrations tend to be heavily factually based, and the law does not go beyond a certain extent. But there may be cases where issues of illegality, enforceability are involved, and it may be pleaded in relation to a particular jurisdiction, typically either the governing law of the contract, which is in dispute, or it affects an issue concerning the place of performance of the contract. And in those circumstances, I think there may be a more sensitivity to the determination of what is the correct legal position within that framework. And perhaps in those sort of cases, it may make sense for parties to actually consider opting in to a mechanism like this, so that, you know, if parties are not happy with a determination, they could go to the court for the court to make a final determination on that issue. Well, having said that, it does go against the normal grain of arbitration agreements, which is why it's an opt-in process that's being considered. And I think obviously also there's an added layer in terms of costs for parties if they're going to agree to that. So, you know, obviously it is an option. So I think as an option it works. Parties can consider whether they want to do it or they think they don't want to do it.
Yeah, after all, it honors party autonomy.
Right.
Yeah. Now, I'm quickly going to go on to the remainder jurisdictions. Very quickly, if each of you could tell us what's going to happen in the near future. Is there something good happening which will make arbitration even more potent and powerful? Kun Surasa, do you see any positive changes coming apart from what you've spoken about, the last amendments in Thailand?
Well, I would say that, I mean, the business people in Thailand, they are having more and more, I think, confident in the arbitration system in Thailand, because, I mean, recent Supreme Court rulings seem to give them comfort that there will be more legal certainty. One observation that I make, I mean, like you just mentioned, that most of the business people, they are quite concerned when they have to select the chairman of the arbitration, whether that person should be qualified, in the sense that the arbitrator have to decide in according with Thai law or not. And like you just mentioned, Francis, if the arbitrator does, if the governing law is Thai law, and if the award is not according with Thai law, I mean, would that award be enforceable in Thai court? Would that be against public policy of Thailand? That's really the concern. And that's been a widely discussion in the market right now, whether that award should not be enforced because it's not in accordance with Thai law and it go against the public policy of Thailand. Thank you, Francis.
Thank you. So we've got 5 minutes. Very quickly, Dr. Quang, any light at the end of the tunnel in Vietnam?
I think like Vietnam will have very great like future for arbitration. And arbitration, I mean, like not only for commercial arbitration, but also for investment arbitration. So we have strong FDI for investors who are using arbitration services. We have very young and talented arbitration community, council. And then we have, you know, most of the international law firm who are also have located in Vietnam. So that's the people also exploring so-called arbitration services. So in terms of that, I see very bright future for arbitration in Vietnam in the next like 5 up to 10 years.
Thank you. Ben, anything to add to this equation?
Yes, thank you, Francis. I think also for the Philippines, we've seen more and more contracts where arbitration clauses are being included. And so arbitration is becoming more and more accepted in the country, especially for commercial disputes. The only other thing I wanted to add is that the Department of Justice has also been studying proposed amendments for Congress to consider to our ADR law. And some of the more significant amendments that they are considering would be to the adoption of a single system, both for international and domestic arbitrations, the enforcement of emergency arbitrator decisions, and also the adoption of the 2006 amendments to the model law. So it looks like the DOJ is looking at keeping our ADR law up to date, and that can only be encouraging for arbitration in the country.
Thank you. Thank you, Ben. Finally, last but not least, by Ari, if you could answer that question as well. Mr. Bernard Lim does want to know if you have the percentage for the first instance refusal of awards. If you have, over to you, Pak Ari.
Okay, but on the, well, I think next it is also important, as I mentioned earlier, that Indonesian arbitration law has already been enacted since more than 20 years ago, and it needs to be amended here and there, particularly on the on how the arbitration forum administer and how the tribunal issue its award. Well, if we refer to the SIAC Secretariat, they have this the important role in handling the case before SIAC. I know that they are also providing a correction on the draft award. It is not necessarily that the award is prepared by the Secretariat. It is, of course, prepared and finalized by the tribunal. But the correction, as done by the Secretariat, is very important. The cross-checking, to know whether the award can be properly enforced throughout the world is very important. I mean, double check on that. Not only the decision, the award itself, but also when it is to be implemented in Indonesia, for example, or in Philippines, for example, or Vietnam, Laos, Cambodia, and in any other countries. So the role in handling the case is very important for Indonesian arbitration forum, and I think the amendment of the Indonesian arbitral award is also due to be amended. Thank you, Pak.
Thank you. So, Pak Eri, if you were to just guess, what would be the percentage of enforcement at the first instance in Jakarta? Would it be 80%? I know the Supreme Court is 95%. Would you be able to guess?
Yeah, Pak, 80%, Pak. 80%, it is effectively enforced. 80%
at the first level. Thank you.
Yeah.
Eri. Now, with that, I think we've answered all our questions dutifully, and I do want to thank the panelists that we've had who've answered all the questions that I've thrown at them and the audience has thrown at them. So thank you, Andre, Kun Surasak, Kwang, Pak Eri, Ben, for having been such wonderful panelists. And audience, thank you for having been so participative and having gotten the panelists to exercise their grey matter a bit more this afternoon. I would now like to hand it back to Kim Beng. Thank you very much.
Thank you.
Thank you, Francis and speakers, for that engaging session on the goings-on in the arbitration space around our region. I hope the panel discussion has stimulated an eager anticipation to preview the website. Please then now allow me to take you to the website and conduct a mini tour. First, a quick video to share what the site is all about. We hope you enjoyed the video. We realized that there was some space to be filled when it came to online resources that focused on news and developments on international arbitration in Southeast Asia and the Greater Asian region. This led to the idea of creating Arbitration Asia, to provide a platform for sharing observations on the current developments in international arbitration in the region, and also to provide some information on international arbitration framework in Southeast Asia. Naturally, we also wanted to harness the considerable experience, expertise, and resources in international arbitration within Rajah Tann Asia to provide the building blocks to start this endeavor. Drawing on the considerable number across our 10 offices in Rajah Tann Asia who specialize in this field, all the content posted is original and produced by the specialists native to the jurisdiction featured. Onto the website of Arbitration Asia then. The homepage immediately presents the content organization, comprising articles and country chapters. Under the Articles tab, you will find a curated library of articles and thought leadership pieces by the international arbitration specialists from Rajah Tann Asia. Issues are addressed topically to provide an appreciation of the trends and legal developments shaping the international arbitration landscape in the region. The originality of the contents is underscored by having the featured jurisdiction authored by our native specialists. Each article features the writer who authored it and is tagged for convenient browsing and searching. You may browse, sort, or search these articles by jurisdictions or subject matter, which are extended to cover other alternative dispute resolution options. There is another feature of the website that highlights its unique Asian focus. One of the value-added components of our Arbitration Asia website is the country chapters that set out key aspects of the arbitration framework of the 10 jurisdictions across Rajah Tann Asia's geographical footprint. The country chapters cover more than the basic information about arbitration in the particular jurisdiction. As you can see from this example, each country chapter discusses in some detail the arbitral laws and judicial framework for arbitration, the adoption of the ancestral model law, the arbitration institutions within the jurisdiction, the approach in the jurisdiction to issues of confidentiality, as well as the approach to issues of the applicable law and conflicts of laws issues. The launch of our Arbitration Asia website marks the beginning of our continuing efforts to share our know-how and information relevant to international arbitration in the wake of the rising use of arbitration in Asia. A key aim of the website is to keep the content fresh and current. As I'm speaking, our editorial team is working on adding more topics in the country chapters. We also plan to call on our friends in the international arbitration space to work with us and contribute content and ideas to help us fulfill the vision of having the website become a go-to resource for premium content on what practitioners and users of international arbitration would find useful to know. If you have any queries about the Arbitration Asia website, or even beyond its contents, please do not hesitate to get in touch with our lawyers from the international arbitration practice who are always ready to help you. We hope that you have enjoyed the time with us and that you find our Arbitration Asia website informative and useful. Thank you very much for being a part of our launch of the Arbitration Asia website, and we at Rajah Tann Asia look forward to providing you with the latest insights and developments in international arbitration across Asia.